Hello, so I'm Alicia Stack, and I'm here with one of our clients, Betty, and we're going to talk about some of her estate planning questions here today. Often clients have questions at the initial interview that they're looking to have answered. Sometimes people are just ready to go, and either way, whatever place you're at, we can help you there. So Betty and I are going to go over some of the initial questions that she has as she gets ready to make her will.
Okay.
So thank you so much for coming in here today and helping us with this. It's such an important process to get started. I know it's difficult sometimes to think about these questions and to think about such a hard time in your family's life, but you're really doing them a favor and something very loving for them to take care of all these questions so they'll have fewer things to think about at a difficult time.
Okay. Well, thank you. I currently have a will,
Okay.
but I need to update it because we've changed our life situation. And I now live with my daughter, son-in-law, and my grandchildren. So I want to make sure, and my husband. So I want to make sure my son-in-law and I, we own the house jointly. And when something happens to me, which, you know, that's the part that's hard to.
Yeah.
I want to make sure that it goes to my daughter so that they have full control over the home. But they have to keep their dad in the house. So that's the big one that I have, and then I just have some little questions about what should actually go in the will, and where we ought to keep it, because we've been trying to find the one that we have right now, and we haven't been able to locate it. So
Well,
I
that's
don't know what we've done with it.
Not an uncommon problem. That certainly happens to people. As far as where to keep them, we definitely recommend making copies. You can file with the Register of Wills. That's right inside the courthouse. You file in the county where you live. They only charge $5 to do that. And that way it's in a central location where anyone can know to look and find it. And if and when you update it, you can then file a new copy and remove the old copy. You're not required to do that. Some people are more comfortable keeping them in their homes, and that's fine. If you have previous wills, you should definitely destroy any previous wills so there's no confusion over which is your most up-to-date will. If they were to find an old one first and start to go off of that and then find a newer one, that could be difficult.
Okay. And actually thinking about that, we did file with one of the counties that we lived in. But it's probably three houses ago. So should we go back and get, how do we take it back from them?
I would recommend reaching out to that Register of Wills and let them know that you've moved and that you'd like to take it off file. And I'm certain that's something that they could help you with. Absolutely.
Oh, okay.
We do not recommend putting your will in a safe deposit box because in the event that you pass and they don't know where the key is or don't have the information to get into that bank, it can delay the process significantly, attempting to get into the box to then access the information about who your personal representative is and what your wishes are.
So we should make sure to give a copy to the personal representative?
That would be very helpful so that they know what to expect. They know they are that person who will be in charge.
Oh, okay. What about other people that you're giving stuff to in the will?
That's really up to you and how comfortable you are doing that. Some people prefer to keep that information more private until after their passing, and other people don't have any problems with sharing that.
Okay. I guess it depends on what the person's got, what they're getting, and whether you should worry about it.
I know people sometimes only think about putting, their most valuable items that have a lot of monetary value into a will, but I always encourage clients to think about items that might have emotional significance for your family. Sometimes it's not a piece of expensive artwork or jewelry that can cause that kind of strife afterwards. Sometimes it's, mom's ring that had no monetary value, but she wore it every single day. Sometimes it's grandpa's workbench, which, one grandkid used to sit and work with grandpa all summer long at that bench, and it's not going to get any money at a garage sale, but it means the world to that person. So especially if you've promised things like that to family members, I encourage you to think about putting that in your will so there'll be no questions afterwards about who it goes to.
Oh, okay. I have 529s for each of my grandchildren and two other who are like grandchildren to me. They all have beneficiaries, but should that be listed as to about the 529s in the will?
So those do not pass through your will if they have beneficiaries named. Accounts like that, especially 401k accounts, IRAs, anything that has a direct beneficiary named, will pass according to whoever has been named as that beneficiary. So you do not need to put those in your will. Sometimes people will leave them to their estate, but it's really unnecessary. You can just directly whoever you want it to leave it to put their names on there.
Okay. And I think my last big question that I have about it, and I'll have to start going through deciding what goes to, is whether or not an adult child, can you set up a trust for an adult child?
You can set up a trust for any reason that you choose to.
And then you could have, the personal representative also be the trustee of the...
You can choose the personal representative, or you could choose someone different if you wanted someone different to be the trustee. Sometimes you'll run into trouble with estate or trusts under a certain value and finding banks to manage those.
Oh, okay. Okay. Right. So, can you tell me the process that we would go through for?
So in our office, if you're comfortable with technology, not everyone is, we do have a form that we can send to you by email that asks very detailed questions about your wishes in case you're unable to make your own health decisions, in case you're unable to make your own financial decisions, and about what you would like passed in your will and who you would like to make those decisions. So once you've signed the retainer agreement with us, we send that to you and you fill it out on your own time. You can take as much time as you need to really think those through, reach back out with questions, and that can be by video, phone, or email, however you choose. And then once we receive that back from you, that's when we start the process of drafting your documents. So it's very much an ongoing conversation. We do our estate planning on a flat fee basis because we really want to take the time to have those conversations and make sure that you fully understand what you're doing and that you're not feeling rushed or hesitant. I don't want to get charged again. I don't want to combine all my questions at once. Just, as it feels natural to you as you think about it.
Okay. I have a living will and I have a medical directive, and sometimes I'm not sure what the difference is between the two of them. But is that something that needs to be updated as well?
We recommend taking a look at it, at least if it's been a long time. So Maryland has forms that they use. There's a statutory limited financial power of attorney, as well as an advance directive. And we look to those as guidance for what to include. You can certainly always include less, but the statutory form is a good place to start. Definitely if you've moved out of state at all, we should definitely review those forms because not every state has the same rules about how they're signed, how they're witnessed. And also, it's when you're in Maryland, the banks in Maryland are used to seeing the Maryland form. So we know that sometimes, even though the rules may be one way, if people are used to doing it a different way, it can still cause problems. So we do recommend at the least taking a look at them and seeing if they need to be updated.
Oh, okay. All right. I think this is some good information. I've been involved in situations where someone passed without a will, where someone passed with a will, but it was in a different state. My mother-in-law lived in Texas, but she had done all of her stuff in Missouri, and we had to do some crazy things to try to get it straightened out.
Every time you update your documents to ensure that they're up to date, correct for the state you live in, and have your wishes in them, that is really a gift that you're giving to your family.
Okay. In addition to what I'm going to give them.
Yes, in addition.
Okay. Well, let's go ahead and start the process then.
All right. Great. We will get working on that.
Okay.
Thanks for coming today.
Thank you very much.
So now that Betty and I have discussed her concerns and her wishes, what she's looking to get out of this process, I will send her a retainer agreement. And if she signs that, then I will send her our estate planning questionnaire to get more in-depth information to start these conversations and know what her wishes are and how best to put those into financial power of attorney, advance directive, and a will for her. And that will be an ongoing process. We will keep having those conversations until she has documents that she's satisfied with and ready to sign.